Hi, it's me, and this is the explanation that I promised you about what's been going on in my life these last few months. I hope that you'll forgive how long it's taken me to send this explanation to you. It certainly wasn't my intention to be so long, and I also hope that you'll forgive me for using this cold and impersonal mode of communicating this story to you. And I hope that after you hear it, you'll understand that this actually is a rather painful story to have to tell to everybody who I love, all my friends and family, over and over and over again. I actually have started this video over again like 8 times, and each time it's just I just don't do very well with speaking off the cuff about it, and just trying to be succinct and to the point and not really, dissolving into a lot of unnecessary detail. So I had sent an email about this to a group that I had been working with, and so I'm just going to go ahead and just read that email, and it'll really cover everything, I think, pretty well. By now, I'm sure you know that the Florida Supreme Court has revoked my license to practice law. Please rest assured that the court's ruling is 100% unrelated to any actual misconduct on my part. There's been no professional misconduct, no malpractice, nothing. Back in September 1998, when I was a third-year law student, I developed depression. There are several situational reasons, including the onset of premature menopause, that I'm sure worked together to bring about the depression. Unfortunately, the timing of it was such that I was required to alert the Florida Board of Bar Examiners, which is the entity responsible for administering the bar exam and for screening bar applicants prior to admission. I had to tell them that I had sought treatment for depression. Even more unfortunate was the fact that I had sought that treatment from psychiatrists who believed my salvation would come through their prescription pads. The various medications they prescribed worsened and prolonged the condition until I finally caught on and rejected psychiatric care. Since then, I have never suffered from any depression or any other mental health disorder or illness. Still, I had to battle the Florida Board of Bar Examiners to win my admission to the Florida Bar. I finally succeeded, but my admission in February 2005 was conditional. I understood the conditions and really didn't mind because I could understand the concern about having to make sure that the attorneys they admit to practice aren't going to harm the public in some way. The conditions on my admission included the requirement that I consult monthly with my mental health care provider and submit quarterly reports to the Florida Bar, and all that cost money. The length of time of the conditional status was indefinite. I was not represented by an attorney at any time because I trusted the Florida Board of Bar Examiners and the Florida Bar. The conditional admission was memorialized in an order entered by the Florida Supreme Court. The court is the bar membership gatekeeper. After about 8 years of complying with these conditions, I began trying to find a way to get the Florida Supreme Court to change my admission status from conditional to unconditional. I found nothing in the Florida Bar procedural rules that provided any guidance, so I sought an opinion from an attorney who practices in this area. He told me there was nothing I could do other than continue to comply. Then, earlier this year, after 12 years of complying with these conditions, I asked the Florida Bar to petition the Florida Supreme Court for an order admitting me unconditionally to the bar. The attorney for the bar refused. As a point of reference, the American Bar Association has a conditional admission model rule that has conditions expiring no longer than 3 years after attorney admission. And again, we're 12 years in at this point. I then informed the attorney that I was going to strategically non-comply with the terms of my conditional admission for the sole purpose of forcing the bar to bring the issue to the Florida Supreme Court for review and for a ruling. I believed then, and believe without doubt to this day, that I was well within my legal rights to seek to have the conditions on my admission lifted, and that I was within my rights to do it in the way that I did it. Then in June, the bar filed its petition for the Florida Supreme Court to hold me in contempt and to revoke or suspend my license to practice. I responded with a well-reasoned, logical, fully supported with law and facts opposition memo stating that continued enforcement of the conditions on my admission would violate the Americans with Disabilities Act. I also argued that the reason for my noncompliance, seeking review by the court, did not constitute contempt of court because my intention was not to thumb my nose at the court or undermine its authority, but rather seek judicial review when there was no other way for me to do so. I really believed that the court would be fair and do the right thing. I thought that the most risk I was taking was that the court would be unhappy with my method, which would result in something being published in the bar disciplinary records that would reveal publicly the fact that my admission was conditional. Public knowledge of an attorney's conditional admission would damage any attorney's reputation and ability to earn a living. I was so certain that the court would rule in my favor that I continued to take steps to build my practice even as I awaited the ruling. I established a physical office location in downtown Jacksonville and had plans to continue to develop Law U. I also had plans to open a law office in the town of Hilliard, where I was town attorney and had been for over 2 years, and to develop some kind of a program to help the veterans at the new American Legion post that is under construction. Then, on the morning of September 20th, I received that order finding me in contempt and revoking my license. I was so shocked that I didn't even start to feel the physical effects until a little while later as I was driving to my new office. Then reality started setting in. I didn't stop shaking for days. It felt like someone close to me had died unexpectedly. I have been betrayed at a deep level by the bar and court. I have been enraged, grief-stricken, sorrowful, and panicked by the sudden termination of my income and devastation to part of my identity. I was given 30 days to close down my practice. Those 30 days were up on October 20th, 2017. I thought I would feel better after it was all over with, but I'm still on that emotional roller coaster. I'm preparing now, actually no, in the email I was preparing, but now I am in Colorado. I've accepted an invitation from a friend here in Golden who has opened his home to me free of charge until I get back on my feet. I have been attempting to find a job out here, but it's not easy. I have sued the Florida Supreme Court and Florida Bar for violating my rights under the Rehabilitation Act and Americans with Disabilities Act. Ironically, or maybe not so ironically, I'm representing myself. I'm very grateful to my friend in Golden, Colorado, for taking me in and helping me out. I'm going to do everything that I can do so that the lawsuit is successful, so that I no longer have to be dependent on the generosity of friends and family. That's the story in a nutshell. Thank you for listening, and thank you for caring. Thanks for your friendship, and I love you.